this special seminar on assessment, search procedure and penalty under the Income Tax Act, a legal and practical perspective. Today's seminar is not just an academic gathering, but an opportunity to gain deeper insight into one of the most crucial aspects of taxation law, which affects not only the professionals and academicians, but society at large. The topic we are about to explore requires both legal understanding and practical application, and we are indeed fortunate to have among us a distinguished resource person who will guide us through this discussion. With great pride, I take the honor of introducing our esteemed speaker for today, Mr. Anikesh Banerjee, who has made remarkable contribution in the field of taxation law. He is currently serving as a judicial member of Income Tax Appellate Tribunal, Mumbai. Before joining the service, Shri Banerjee was practicing as an advocate in the High Court at Calcutta and ITAT, Kolkata bench, and as the partner of legal firm Messrs. D.K. Banerjee and Co., which was founded by his father and served for more than 50 years in this society. His field of practice was both income tax and GST. With his extensive experience in the field of income tax and its practice and procedures, we are certain that today's discourse will enrich our knowledge and open new avenues of thought. On behalf of the Department of Law, Sister Nivedita University, I warmly welcome you, sir, and we are truly privileged to have you with us today. May I now request Professor Dr. Manik Chakraborty, Professor Emeritus, School of Law, Sister Nivedita University, to kindly felicitate our resource person as a token of respect and gratitude. Students, please clap. Thank you, sir. May I now please request Professor Dr. Debashri Mukherjee, Dean, School of Law, Sister Nivedita University, to kindly felicitate our resource person. Thank you, ma'am.
Now, without taking much of your time, let us now invite our distinguished resource person, Mr. Anikesh Banerjee, to deliver the special lecture on this significant theme. Please join me in welcoming him with a huge round of applause.
Good afternoon. Good afternoon. The Dean of Academics, Law Department, Professor Emeritus and dignitaries, the other professors, lecturers and the students. So today I am going for tax law. It's not very popular for the students because most of my practice I see everybody is interested for first civil, then criminal by going through the serials and cinemas, and later on tax, but little bit tax is now popular because of the raid cinema, first and second. But first of all I am giving you one information that go for any dilemma. The practical applicability of the practice and the cinema and serials and all visual medias is not the same. It's a different applications, different theory. Because most of the time if you go for the court, you see within seconds, because when I'm sitting in the court, I listed matter is near about 60. And if I'm getting the 60 minutes time, so you can understand I have to hear, I have to, giving the proper time, I have to allow the adjournment, two sides, every matter average, if it is 60 matter, 30 matters, so 2 minutes per matter. So you can understand how much the serial is giving you the every episode. So it's not possible. Second, why tax? tax has a very big aspect. Going to my proper discussion on this subject, I am first see you. First of all big force who are dealing with the tax, they have a high demand for the tax lawyers in Calcutta, in Mumbai, in Delhi benches, in especially GST, income tax, NCLT, NCALT. So service tax is not now here. So these are the basic 5 benches. They are highly required for the tax. Second, the tax has a regular amendment, because when the government just find that there is a loss of tax, so they are immediately going for amended. So whatever maybe the client is doing, they not be aware on the regular amendment, because regular amendment only knows the tax practitioners. So I first introduce my speaking as a start, my speak. So in this way, that first you have to take interest on tax, and there is no such any hard mathematics. It is a simple arithmetic sometimes required, but mostly the explanation of law. Mostly the explanation of law. There is no mathematics, cos, sin, theta, nothing is required. So that is the basic thing. Then tax, I started my career with other tax also, but finally I started tax, and tax is my most interested subject now. But going to the income tax, today's matter is related to assessment, search and penalties. So it's a very huge subject starting from this section. So I am going through this only the old act 1962, because you know the income tax is also now going through the new act, and already parliament has passed, the lower house and higher house, this is going for the bill. So I am not going to this act. Basically this new act has no such any big changes, only the sections, subsections are braked to coming to the section, and the provisions are going to for sections. So there is no such any big changes, but most of the act style and penalties, everything is the same. So going to first assessment. So first I going, just ask you one thing. You know the return of income, most of you may be going for filing the return, you know from. So if you file the return, which section you file the return, you know? Tell me anybody. Which section you file the return? Basic. Okay, so you basically you know the filing is return is under section 139(1). That is within due date is the filing of return. If I am going to this return process, there is 2 years. One is called the assessment year, another is financial year. Later on it is changed in the new act, it will only come the tax year. So it's a different, I am coming only the 1962 act and rule is 1963. So 1961 act and rule 62, that is the only thing is that the return when you filing of your income to the government of India in the income tax department, that is the first section is starting is 139, and 139(1) is the due date. Due within the time you are filing your return, that is 139. Next is belated return. If you file the beyond your due date, it is belated return. And if you go through that the late return, that is a belated return. And if you revise your return, if you file within the year, if you want to revise your return, that is going to the 139(4), you revise your return. And finally, one section is there, that is a defective return. Suppose your return is defective, the department will give you the time for another 15 days, 20 days, you will just rectify your return, and that is under section 139(5), that is a defective return. The point is that the section 139 beyond, you have another sections you can file the return, that is 142(1). And section 148, and another is very important section, that is a search section, that is 153A and 153C. Why this I am telling you. Suppose you have not filed your return, government found that the revenue found that there is some concealment of income. They found that there is some transaction which is not the under the normal purview of the income tax department, like that of you paid your credit card bill more than 1 lakhs, you maybe foreign trip made more than 7 lakhs. That information came, but they find that your return of income is not supported this type of expenses. Your club bill is more than 1 lakhs, whereas your income is coming 2 lakhs. So after deducting your regular expenses, this club bill is not possible. So in that case, they are going to issue the notice under section 142(1), and on that basis you can file your return. But the scrutiny assessment will start, that I am coming later. The second part I am telling you, that is a section is called 148. That is the reopening section. All I am telling, it is beyond your time when lapse that you have filed your return period is completed. 1 year is the return period you have to file. If you failed, then the income tax start proceeding from your information, and all information they are gathering from ASI, arthat that is that system of online system. And that particular online system, they are gathering their information and they are issuing you the notice of reopening. So reopening, first notice will be issued just opposite. If you go for 148, they have issued the notice and they complete the assessment in 147. Usually we think first notice should be 147 and assessment should be 148, but there is a reverse. But there is a time limitations. There is lot of amendment was made. The final amendment, current amendment, if you have a concealment less than 50 lakhs, it will be within 3 years, 3 months, they can reopen your file. And if it is more than 50 lakhs, that is the 5 years, 3 months. That is exact current effect. And there is another act they can go, that is not I will go through, just for information I am telling, that is the Black Money Act, and that will be assessed under PMLA, Prevention of Money Laundering Act. That is a separate, that is not the system for today. So when they see the concealment, if it is less than 50 lakhs, suppose you have a concealed bank account, you never reflected in your return, or you have not filed your return. You have filed your return, but not showing your income, which is stated as per they got the information. Some transaction you have made, any foreign transaction, any Indian transaction, which is prohibited by any of the law. Suppose you have made some PMLA Act, Prevention of Money Laundering Act, huge cash deposit, but not reflected in your return. Or the officer has a reasons to believe, that is very important. In several time in Supreme Court, in the case of Kelvinator, in the case of a lot of cases like Zaveri cases and others, the Supreme Court very specifically told that there is a reasons to believe. So there should be reasons to believe by the officer that they can reopen the file within the 3 years, 3 months and within the 5 years, 3 months. So they can assess and complete the assessment under section 148, and accordingly they can make the demand. That is the second part for you can file the return that time. And there one very important judgment that I am telling, that is the GK and Drives Act. The Supreme Court has made the process how to file your return in 148, how to call the reasons to believe from the officers, and how to file your objections. And after objection, the officer dispose the objection and going for assessment. There is a process. Later on, the income tax department has changed the entire system, and they have made 148 with 148 capital A. And you see lot of cases, your professors knows very well, that lot of cases recently that Ashish Agrawal, Justice Chandrachud, and in case of Rajiv Bansal, they have made a specific direction related to this reopening, because the COVID period was there, so that time issuance of notice, and you know that the Supreme Court had made a specific suo motu petition, suo motu applications, that for 2 years any of the act should be come under the condonation of delay. Delay should be condoned. So on that basis, the 148A process is specially designated, specially defined by the Supreme Court in two cases. One is Ashish Agarwal, another is Rajiv Bansal case. What I am telling it, because 148 now, read with this section 148 capital A. Capital A, first they observe, issue the notice, ask for the clarification, then B, then C, and then D. Finally you have to reply. Then they have completed all these, their observations, their reasons to believe completed within this period, and after that they will go for the assessment. So this is a new section of 148 capital A. So very importantly, that is the time. After that they will complete their assessment, and accordingly they will make their demand if required. Otherwise you can drop the proceeding. That is the second way. Third way is that, very important, you see the search and seizure. That I am just told you that this Red cinema, one very popular for the year, that is the specific for the search. So search is related two part. One is 153A, 153C, and 153B, the specific, and 153D. I am not going to in the full nitty-gritty, it will be more boring now. Because of that, otherwise you will not interest to see, hear this whole my deliberations. The what is 153? When the search is conducted, when the department enter in the place, and they can search anywhere. Search not only for the house, office, even they are going in train. Lot of time that is happened. The person is going through train, and they are within the train, they made the search. So that is also the search. And very importantly, sometimes happen, the person is carrying money, and police is made the naka in sometimes, and police catch the person, and they see the 20 lakhs, 10 lakhs, 5 lakhs cash, and the person is can't explain this. The police catch the person. Finally, they are handing over to the income tax department, and income tax department is taking this as a search action. Suppose you see lot of papers, you see the ED raid, CBI raid. Finally, all this raid, whatever the money will come, that money will go directly to the income tax department, the entire proceedings of the ED and CBI, and finally the income tax authority will take it and they are assess the tax accordingly. Only ED and CBI has only to catch the person, catch the money, and that is their, they are complete their investigation. Finally, this assessment purpose they will send to the income tax department. Then this search action is happened. Another is very important section is that 153C. Search conducted, but some documents is found for the other person who is not in this place, who is not attached with this family or in this company. The documents are received which is related to that person. He will come under the 153C section, or that person is indirectly related. The officer will ask, if he is not explained, they have given the notice and they will file their return. Then another opportunity. Same as 153A, they will file their return through 153A. That is nothing but they can give the another opportunity to disclose their income, but the judicial system is not giving so many support. Suppose income tax catch my 1 crore rupees concealment, and in 153 notice or 148 notice I declared this income, and I feel when they catch and I declare my income, so this income will be after all no tax. So I will get the benefit of the penalty, I will get the benefit of interest, but it is not that. It is a mere proceeding to give the opportunity for filing the return. So this is the another section for 153C and 153D. So this is our more or less filing of return during the time of normal due date, then notice under 142(1), then 148, then 153C and 153A. Then we are going to, after filing of return, what happens? There is one section is called 143(1). Primary condition is that when you file the return, they will just inspect your return. Very commonly, just to calculate the tax, whether any shortage of tax payment. If you have refund, they will give you the refund. If you have feel that any section they are wrongly charged or the deduction is wrongly claimed, they will automatically, they will issue a notice for rectification, and accordingly they will assess, not assess, they will complete their calculation. I am not using the assess intentionally, because this is an intimation. Sometimes in Kalyanpur cement, in case of Calcutta High Court, is very specifically in Supreme Court also, that this is not a order, this is a mere intimation, this is not a order like that of other section. So they will give you the 143 notice, and accordingly the tax will be payable. If you feel the tax is payable, you pay the tax. If you don't feel that tax is not a proper way they compute it, you can go for the rectification. That particular rectification is under section 154. So this 154 section you can file for rectification of income. The department will verify. If they feel so, you will rectify your income. Otherwise, they will give you the final judgment. No, that is the final 143(1). So rectification is rejected. Then the next proceeding will start, your appeal. That I am coming later. What is the appeal? Appeal will, on that basis of 154 or even on 143(1) intimation, you can go for the appeal also. That is under section 246 capital A. That I am coming later. Then suppose your assessment is complete by notice of 143(2). That is your normal return you filed. They feel that 143(1) is not sufficient. They can assess your income by the two mode. That is called limited scrutiny. Another is for the full scrutiny or complete scrutiny. What is limited and complete scrutiny? Suppose they find that any income or any concealment is for limited purpose that you have not declared in your return, or mismatching. Like that I already told that suppose they think that your electric bill is higher than your income, your club payment, your credit card payment, even your payment to in any of the gift to anybody which is coming through this income tax information, your shares, everything. That is under the limited scrutiny. That is fully the machine oriented scrutiny. That is not that particular thing the officer can find out. That is a machine oriented scrutiny, and on the basis of the machine oriented scrutiny they find out, and accordingly they go and decide whether it is a complete assessment or whether it is the scrutiny is limited. So when the process for the limited, they can find that there is a big concealment, they can make this limited scrutiny to the complete scrutiny. So this scrutiny part, they can scrutinize and issue you the notice 143(2). That is very mandatory, because without the notice, none of the officer can proceed for the assessment. So when this 143 notice will come, so the process of assessment will complete. Accordingly, they will give the reasonable opportunity by issuing notice 142(1) and complete the assessment. And after this assessment, when the demand will come, you can pay the demand. Otherwise, the demand can be challenged in the appellate section. That is the first appellate authority is forming the CIT appeal, the Commissioner of Income Tax Appeal. The assessment and the appeal as per the new norms is a faceless. Because of that, you will not able to see the who is making your assessment, who is doing your appeal. But you can go through this faceless assessment, and there is notice will come on your box, this your account box, and if you feel any one-to-one virtual hearing is required, in that case you will give your proposal to the department, and finally they will give the particular officer will not come, there is a process, and assessment unit will give you the opportunity, and you can make a virtual, this face is hidden, and you can do your voice and face will be changed, and accordingly you can complete your appeal and assessment in this way. Then after this appeal, you will get the appeal order, section 250, and after this appeal order, you will verify this appeal order. If you feel so you are not happy, you can challenge this to the tribunal. That is the Income Tax Appellate Tribunal under section, and this they will give you the hearing, and that is not a faceless. That is on the court, and same type of court. they are giving the opportunity for hearing, you will complete your hearing, and if you are having any grievance, you can go High Court and then Supreme Court. That is the entire process. So the entire assessment proceeding is same as the 143(1) after completion of your filing return, second 142(1) notice that you have not filed your return, or there is any, you have not filed your return, but you have filed your return through notice under 142(1), the second scrutiny, and third is very important, that is related to 148. That 148 notice, you filed your return, you process your 148 A, B, C, this accordingly, A small, B small, C small, D, and finally the assessment happens, same system. After this assessment, you will go to the CIT appeal, then tribunal, then appeal, then, so you see, normally in search case 153A, same as it is 153A and 153C, if you filed your return, and accordingly the scrutiny going on, then the same process. You see, when you're doing starting from appeal, maybe you are not filing the return as a lawyer. So if you go through this process, you see when the client comes to you and if you giving this service to him, how much steps you are covering. First assessment stage of 1 year, then appeal another 2 years, then tribunal another 2 to 3 years, and then finally High Court and Supreme Court. So you see this list of proceeding you are going, and suppose when we see the 148 reopening happened, or 142(1) notice was happened. So when the department basically able to catch the person on any concealment, so normally that is going on, except the client is giving the consent, okay, you pay the amount, this battle is going on till High Court as per the client's economic positions and others. So there is a big channel you can cover up from one to end. Then the process of search is very important. You see this lot of searches in very different of areas. You heard that search proceeding is going on. The search procedure is fully the undeclared process. They never tell you I am going for search. The team can come to your office, your premises, residential premises, even your relatives, even in the train, even in the airport, everywhere. But there is two difference on that. One is search, that is 132, and one other is survey. Survey is another proceeding to complete the proceeding of inspection. What is this? The survey can be done only for the business purpose. That is, survey proceeding is the only for business premises. That is the only difference. They can only go through the business. That is business premises, books of accounts, the everything. They can't enter in your residential area. When they enter their residential area, they convert this entire survey to search. And when they enter in the residential area, they will touch your everything, any private belongings, your almirah, bags, everything they can hear. Because suppose a person conceal one diamonds, they will never give these diamonds in openly. They maybe put it in an almirah very concealed way. So in that case, the search is a fully completed residential, office, relative, everywhere. You see this search. Normally, the search is happened by team, because nowadays the entire government system is made by a one roof system. If they started the search, sometimes ED, CBI and income tax both joint search. Sometimes ED and CBI started the search, later on they call the income tax authority, feel so. And if they feel no, there is not required for the income tax now, they will search and the material they gathered, and accordingly they will send to the income tax department. So this search, when they accumulated all the documents, they are giving the opportunity to filing the return first. Number two, there is one point is called the requisition. What is requisition in search? Because whatever documents you have submitted, they are going through this document, sitting with the assessee or assessee's representative, and completed the concealment, completed the concealment one by one. After that, they give you the opportunity for declaration. And this particular declaration, sometimes it is not happened, not the final, because the statement before the AO is not a final authority, they are not a judicial magistrate. So when they come to this, they are prepare the documents accordingly, and finally they are sending it for assessment, because search is not completed by the assessment. Search is only the process of inspection. They collected, gathered the documents, and accordingly they sent to the assessment proceeding. Same assessment will happen that I told you later on. This assessment completed, demand comes, and you can go one by one to the step of the appellate authority. Same as it is on the 153C case, whether there is not a such person other than such person, but it is related to this such person. Some documents, some jewelry, some specific, maybe one builder is such. They say this lot of on money transaction. What is on money? That the something they are paid in cash, something they are paid in the by check. Suppose a property is value is 1 crore, but builders took it 80 lakhs by the check and 20 lakhs by the cash. And they have noted in a proper sheet, even in the WhatsApp. And when the such person caches this phone or the documents, they are basically, through the investigation, they come to know that you are of the one of the person, this person who has paid this cash. And this person of the builders, they accepted, yes, this 20 lakhs I got the cash from there. Then the fight will start, and accordingly he is not a such person but the related person, and accordingly they will issue. There is very important, very crucial judgment is there in Supreme Court, and Avishar Bildwell. So how the search will process, that is question of abated and unabated years. Just I am giving this sound because if I am going to enter this way, that will take another more time. So I have to explain more. So the Avishar Bildwell in Supreme Court and Justice Bhatt, Justice Bhatt, very extensively made, and it is just like the Gita of the search proceeding. So what the search proceeding will be issued to notice to the person, and in case of 153A, or what's the cases it will be happened for 148, that is reopening, that I am already told you the question of reopening, because search is only related to this year, what is unabated year, that is the year is not able to reopening the cases, so they can issue this to the 148 to the other cases. So that I am not going to, but the cases I am just giving the task that you can remember. This one is a very important judgment of Avishar Bildwell. So on that basis they will complete the 153A and 153C. Then the matter will come to the CIT appeal. That is the first appellate stage. An appellate authority give you the opportunity by issuing notice, and you can file online. If you feel that virtual hearing is required, accordingly they will give the opportunity for virtual hearing if you want to say something on this issue. So that will be happened. And the next issue will come to this. After this appeal, it will go to the Income Tax Appellate Tribunal. That is the tribunal is a like of court, not a court, but it's a like of court, and you know the difference in between tribunal and court very well. So when you come to this tribunal, it will give you the opportunity of hearing, and the department will also appear. They will also, they will argue your issue against you. There is tribunal, there is specific dress code is there for, there is black coat and black pant and decent tie, decent shoot. For the ladies it is salwar, shoot and shadi, and with a decent coat. So on that basis you have to appear, file your wakalatnama, and one part is that if there is delay in filing tribunal, you can file the condonation petition. So entire proceeding of this income tax gone through by open court. It is not that any of the faceless, that is income tax and in case of appeal also, in assessment and appeal. That is not a case of you will go through any faceless way. So it is a open court. And very importantly, that if you file any evidence, that is very important. Evidence part is income tax is a different issues, and very exhaustive. That is also the evidence. If you want to file, even if you want to file any of the new grounds, you can file by the additional evidence and the additional ground. And additional evidence, when you file, the department will get another chance, and obviously the tribunal give you the opportunity further for verify the additional evidence. It's a very common cases is the National Thermal, NTPC, that how to accept the additional evidence in any of the places in the appellate authority. Additional evidence and additional ground you can file, and separate hearing will be gone through. And if the tribunal feels so, that will be adjudicated there, they will complete their adjudication, and if they feel so that this particular adjudication is not required, that should be verified the other authority, they can set aside to the income tax authority or to the appellate authority for verification of this particular additional evidence. Because sometimes it has happened, the normally assessment and appeal done by the one of the lawyers, but they have not able to verify what's the excess material required to plead the matter before the tribunal, and accordingly they will go on through the new lawyer, and they find there is another evidence and another grounds is required, maybe some legal grounds, or that they can take it. But tribunal is the last fact finding authority, so that is they are the final authority for the verification of the fact. So normally when the matter is carried to the High Court or to the Supreme Court, they are not taking any factual matter. They only to verify the question of law. Question of law is the only basis of the High Court and the Supreme Court. Supreme Court is not even going to, because High Court is only verify this substantial question of law and question of law during the time of appeal. So there is no factual verification by the High Court. Factual verification will be done by the last authority, is the tribunal. So any of the evidence, additional evidence or any evidence if you want to file, that is come under the complete by the tribunal. Then the second part will come. After that, the department, if you have demand, they will charge the interest. The interest is part is specifically for 234A, B, C, and normal tax rate, you know, that is the 30% is the highest rate. But if they found that any of the addition made and the source is unable to explain, suppose a huge amount of gold you have received and that is found during the search. Suppose the international bank account. Suppose the cash they have received, the person cannot explain. This cash maybe some other way they have received this cash. So they will charge you the tax 80%, not 30. So almost 80% they will charge, and after that interest, it will go to 110 to 120%. Mane more or less how much you have concealed, the more than that you have to pay. Because of that, 60%, 115 BBE section carries this 60%, and others charge and surcharge everything, if you include, that is 80%. And after that 234A, B, C interest. So almost it goes to 120%. So more than concealment, you have to pay the extra. And it has happened, it's not happened, it's not like that. So if you able to explain the source, that it is my business income, my stock was there, and this stock was coming through my particular business income, and this particular stock I concealed, I never declared. This particular, if you are able to explain, then you can get the relief of section 115 BBE. Otherwise, it is not possible for you to get this relief 115 BBE. You will be charged 80% tax plus interest under 234A, B and C. 3 interest approximately per month it will come to 4.5%, approximately you take it 5%. So in another 60% it will come for yearly basis. So the interest part is a very, very vital part for the tax part, and sometimes we see that on the interest part, the people will be finished on, they are ready to pay the tax part, but the interest part, they will get tremendous pressure on interest part. But only in case of, if you have a 234 interest, in case of B, that you will get the relief. If it is once in a lifetime, you will get the relief. If the income tax authority found, higher authority, chief commissioner, that the particular interest once in a lifetime, never earlier, and later you have not made any concealment, it's a one time happened. Sometimes they are giving you the relief under section 119(2)(b), that the particular interest part. But it's a very rare thing. You have to show that is the only thing it has happened. But if it is regularly happened, there is no question of any interest part. So how much? If he is a concealment, 30% tax, 30, now it is 34%, everything surcharge. Then interest approximately 60%, 50%, so 80% gone. And if you implied the 115 BB, the 120% gone. Then it is not stopped. यहाँ पे खत्म नहीं हुआ. That is not ended. Okay, I ready to pay the tax, I ready to pay the interest. No. Then the next part will come, the penalty proceeding. That is the separate proceeding. So if you count it, as I am a tax person, I am telling you, if you count it, how much proceeding you get if you get a such litigation as a lawyer aspect. You just count it how much. One is tax, another is interest, then come to penalty. Very broadly, penalty first, it is going through by this section 271(1)(c), that is concealment and inaccurate particular of the income. Now 271(a) is not implied, that it is not applicable now. The section 270 capital A, that is one section. Basically, section 270, 271 is the section for all type of penalty. If you not filed your delayed filed return, 1,000 rupees, that is a 271F. If you filed late your tax audit report, 271 small b. Even if you not appear before the any of the authority, appellate authority, assessing authority, per day, per appearance, 10,000 penalty. So if you not appeared 3 times, 4 times, 5 times, if you, huge amount, huge amount. So I'm just telling that how the proceeding is going on. Say, on a lawyer aspect, a lot of proceeding, maybe the penalty and others is charged and suffered by the author, SSC. That's a very tragic part, but that's a different issue. But from lawyer aspect, how many proceeding you will get it? That is the interesting part. Then every point they will give you the further so cause notice, 274. Suppose you have not appeared 4 times, so they will issue you another 4 so cause notice 274, or by a single, that 4 days you have not submitted. If they feel so, they will allow, officer, generally they don't do, they will do this by this, through this penalty they imposed, and if you further go to the appeal, further go to the tribunal. So tax interest is not at all completed, you complete it through the penalty, come to the penalty part. So in 271A is now the new section, it is, this 271(1)(c) is just, it is abolished now, and 270 capital A is imposed, and the 271 capital A is reported income and underreported income. Suppose your return you have declared, that is 1 lakh rupees, and your assessment it is come to 2 lakhs rupees. So 2 lakhs minus 1 lakhs, the balance 1 lakhs you have to pay the penalty 50%, it will go to 100%, even it will go to the 200%, depending on the intensity of the concealment. That is 60 plus interest 120%, then come to penalty, it is 50%, 100% and 200%. That goes to more or less 300% of your concealed income. Then penalty in each and every point there is a penalty. If you file delay return, penalty. If you are filing the tax audit report, that is a different part of the business. Who has an income more than 2 crores, they are submitting the tax audit report, that is a separate proceeding. So there is another 1.5 lakhs penalty or 2%, 1% of the turnover and maximum 1.5 lakhs. And there is other penalty for every delayed filing, for trust, everybody. So all the penalties will go through the same process section, except 274, they are issuing the show cause notice. You comply the notice. If you are happy, they will allow the penalty, mostly not. They will impose penalty and go to the appellate authority. Next, after this penalty and tax, if you paid, it's okay. Otherwise, they will issue you for imprisonment. The process of compounding is in another process. They'll start the compounding. What is compounding? They will found the 1 lakh rupees. They have started the prosecution. Whatever the court you will go, any of the any judges court or everywhere, they will one thing that no, I will not able to do. You will come from income tax, and if they are giving you the fit certificate, I will allow you. Then when the compounding will start, if you proceed to the department, this is my compounding part, what can I do? So the first word, what's your concealment? Now concealment is 1 lakh rupees, 1 crore rupees. You pay another 1 crore rupees, I will release you. So tax, interest, then penalty, then compounding. And compounding, mostly it will then come to the negotiations, sir, leave me this, already we have paid. Then you come the 50%, at least 50 lakhs, I will relieve you the compounding. So that is another process for the compounding. So that is the all for the return for individual. And there is another part, is called the TDS. And that is a very pathetic part, and professors very well known, that every salary you are deducting TDS everywhere in dividend, your interest, everything. That is a different part, will start another proceeding. That is applicable basically for the companies, firms, but for individual you can do, sometimes you have purchased the property or sold the property, that you have to deduct the TDS. If you pay, then you have to deduct the TDS and submit it through this form, and that is done through your PAN. But if the TDS is gone through by a company or firm, I will not go for any detail of this, what is company, what is firm, what is AOP, association of person, maybe you know all. So they will get another number, is called TAN number, tax account deduction number, and on that basis they are deducting tax. Very interesting part, if you delayed the filing return in any of the TAN return, every day 200 rupees penalty, late fee. So every day 200 rupees late fee, but unfortunately you have to pay the late fee and then you can submit. So there is no question of appeal, because appellate authority has nothing to do, because no such any medical, and there is, if obviously you can go through the appeal, but every day that is a 200 rupees penalty. If you made the wrong return, and if you go for rectification of the return, any change of income, they will charge 100 rupees per day, per day. So if it is 1 year, you can understand. Then how much you have concealed, there is another interest and everything. So if you see this, the proceeding, so lot of proceeding can be happened for a consultant and for a lawyers in every moment. So one is TDS, another filing return, another search. So everywhere they are fully covered by the SSC or our civil people in every point, except the agricultural income is non-taxable. Otherwise, mostly all the incomes are taxable. And now what is happening, if you see the GST, they are directly getting the information from the GST, and GST getting directly information from income tax. Their portal, their interacted portal, their portal joined. So if you have a cell in the GST 2 crores, or you income tax you are showing the 1.5 crores, they are very easily track it. And within the moment they will, through processing or return 143.1, they will give the show cause. So this way Government of India made the entire system in a very, very compact way. Very compact way, everywhere. Even if you sell a property, if you pay the electric bill, if you pay the credit card, hospital, everywhere if you pay, within the moment the information gone through by the AIR, Annual Information Report. If you pay the, deposit the cash more than 50,000 in a saving bank, 1 lakhs, more than 1 lakhs in current account, in business account, automatically the information go to the income tax department, and income tax review the show cause. When a show cause will come, every time we can make our bill and we can charge our concern SSC every time when you got a single show cause. So there is entire issue is fully covered by the income tax department, our process of income, and this is a very nutshell I am just explained, because every unit if you go through the income tax, in TDS, then you have to explain in deeply in every, but it will go very boring for after all. After all, it's a tax. Sometimes I am get bored in the court also. After 12:30 and 1, I am also feeling bored. It's not that. And another part, I'm just giving you very general, is a international taxation. I'm not gone through this. There is a transfer pricing adjustment, there is international taxation. There is a very big sector. That transactions with the international entity, with the Indian entity, and very common cases are there, Nestle cases, Nestle India. The Supreme Court defined the permanent establishment. The company is here, and their company, another company state is German. So they are, sometimes we see the software company, everything they are controlling from maybe USA. Their employees sitting here, but they are controlling USA, their office, everything in Singapore or outside India. So whether it is defined under permanent establishment or not, and accordingly the tax will be charged. They are getting the money from their company, or they are paying this money, and accordingly the interest will be charged. So this is a different sector of the TP, transfer pricing, and that is the another international taxation. That is a different section I am not going through. This way it will be, is a vast chapter on that. So there is a lot of aspect I try to show you that is the income tax has that, and which is fully related in our day-to-day life, obviously. That's all. Thank you very much for your patience hearing. Thank you very much. Any question?
Students, if you have any questions to ask, yes?
So, sir, I have a few
No,
questions.
please.
I have a few questions for you. So, my first question came to mind when you were talking about faceless assessment. So, for faceless assessment, how has it sort of created new rights for taxpayers and departmental obligations? How has it done it in such a way, since this is such a newer process?
A new process.
Yeah.
This is going through your, when you issue the PAN number, just like your bank account, they're giving you an account, and accordingly your notice will come and you will reply this process.
But how has it changed, like at us, the taxpayers' rights, as well as your department's obligation? The income tax department's obligations.
That is a parliament process. This so there is no question of that right.
Oh, okay.
And I can remember the cases that was challenged before the Supreme Court also. But in question of the IT rules and regulations of that, that is Information Technology Act implementations. So their right is fully covered by by that.
Okay, and
That was challenged near about before the COVID time. It is challenged, and Supreme Court is very clear that there is no question of the right is denied of the our civil people. There is no right is denied.
Actually, my second question is that we know how the new Income Tax Act 2025 has, sort of like become more succinct, and has reduced the number of sections. So how will that impact judicial interpretation, as you transition from the 1961 Act to the 2025
Just
Act?
I am giving you one information if I am getting it. The new tax bill, that is the income tax bill, there is no change of reduction of section. I am just giving you one here. The in old act, in 61 Act, the provided further, that is a very important word for the income tax, was 340 times, here is 0 current. Explanation was 1257, in new act it is 26 times. And the important is that new concept of tax here I already told. And basically the section, they are more and more section, near about 800 sections are there, because the proviso, these subsections, they are segregated it and made it under section.
Okay, okay, sir.
800, approximately 700. We are in our Goa conference, we are also the part of the with the revenue. So we have made some other points are there, but now I feel so they are more or less 700 plus, because every subsection, every proviso, they made it as a section. Because deemed income is another part. They are made it deemed income is related to this income particular. Suppose you have an income, or you sold a property. A property when you sell, there will be capital gain tax. So you sold the property in the value of 1 crore, but government valued it 120 crores. It's a very common, you see that government made it 120 crores, 1.2 crores. So this 20 lakhs rupees is your taken as a deemed capital gain income. So particularly this was also related to this income. Deemed income is also related to the main income. That is made a separate section.
Also, my third question is actually
yes.
very light-hearted. So, as you know, a few years ago, actually, some income tax officers had conducted a raid by disguising themselves as members of a wedding procession. It's very humorous. Have you encountered other such similar but very humorous cases in your practice?
A lot of cases are there. But one is, I'm telling you, the train. They have made it a train. Search in the train, running train, they have made a search. And lot of cases. One CBI information I am getting from our ex-CBI is now our member, one of the. So they are telling that one, they gone to the search for very important in Kashmir area. So first they started, what happened normally, the trading going on in between Punjab and Pakistan. So this particular trading, that earning some commission, and this commission by the brokers. Basically this commission earning to their just feed the militant.
Oh, okay.
The person I am telling, he is also very popular. His name is something I can forget. He is a commissioner. So he is very important in greenery. He is doing some green everywhere. So he started investigation till he went to the end of Kashmir end and this money trail. Finally he checked that this particular money trail is fully covered by the militant. So he involved the NIA, and normally NIA can't proceed there in such a huge vulnerable areas. So they are going through this army joint directions, in joint raid made, and number of militant, 20 or 40 militant they able to catch through this search.
Wow. But thank you so much.
His
sir.
name is Rohit Mehra. He is a very popular in Instagram and everywhere. He is doing some greenery everywhere. He is preparing the forest. Small forest they are preparing in Punjab areas. He is very popular. So he is telling me that from this particular such, and everywhere it is happened. Because you see, whatever our militants used to come here, or they are doing, without money they can't survive.
That's true.
Money obviously required, otherwise their regular expenses, the arms, everything. So this money trail income tax is try to catch. When they able to catch, they are going through the NIA. But what happened is, very frankly, when I sit in the court, NIA made the raid. The person is taken some grocery from grocery department. So naturally this militant is there, regular grocery, food required. So they are taken this and they put this bill in their custody. After all, they give some accounts, hisab to other also. NIA raid him and also raid this shop also. That is a part of that. Later on they will come to the tribunal and will take a cognizance on that and every document, then it's a issue. But it's a part of that.
Thank you so much, sir. That was very informative and also entertaining.
Thank you. Yes, yes.
Whether under-reporting of income and misreporting of income, are they treated differently
Correct.
in penalty procedures?
Correct. Under-reporting and misreporting. Suppose you reported not fully.
Yes.
You made turnover 2 crores, you reported 1.5 crores. That is your under-reporting. And it's a question, it's a very, you are obviously professor, no?
Yes.
That is the reason you asked. That is a very minute difference in between there's a very common legal issues are there. There's under-reporting and misreporting. That is that we generally treat it as a misreporting of never reported. Suppose you sold a property, you never reported. This is a misreporting. Normally in business, we are treated as is a under-reporting. But in case of you have bought a jewelry, 5 lakhs rupees, you never declared. If there is a provision, not through your concealed bank account, not your normal bank account, or you purchase this through cash, and cash is not able to explain, you are a salaried person, don't take otherwise. So you are a salaried person, but you are paid through cash. So that is coming under the misreporting. Obviously. And what happened, for jewelry, there is a limitation. If he is coming to this limitation, suppose 2 lakhs is the limitation. Within 2 lakhs, if you purchase anything cash, the authority should not be, the shopkeepers did not inform to the income tax department. If it is more than 2 lakhs you purchase, they have to deduct TDS and getting your PAN. Charge the tax. TDS, not TCS, they will charge 1% and collect. There is nothing, 1% is nothing. If you purchase 3 lakhs rupees bill, 1% means 300 rupees. 3,000 rupees, nothing. But they will getting your PAN. That is the information income tax will come, and that will be informed to the AIR. But you purchase is less than 2 lakhs bill, and you make it 5 bills. 1 lakh, 1 lakh, 1 lakh, you made 5 bills. Obviously, income tax department didn't get the information. But later on, income tax able to catch it. 5 lakh rupees, that is the misreporting. That is the concept was basically the 271C. But what happened 271C, there is one concept is concealment and misrepresentation. The point is that in everywhere department is losing the cases. Because of that, the notice when they issued, that is very important, I told that 274 notice. When they issued the notice, normally the clerk not deleted the particular part whether concealment or misreporting of income. They are not deleted. So when they not specified, Supreme Court very specifically in first of Karnataka, in Manjunath Cotton Mill, told that no, this is not specifically mentioned in the notice. If the notice is not specified, the person can't know where is concealment. And on that basis, matter carried to the Supreme Court. And Supreme Court later on basis of the, not for argument, on basis of the leave, they rejected the leave. And anyway, the Supreme Court whether rejected this, we have to honor this one. And this way, department is continuously losing the case. They have changed this to 71A as a under-reporting and misreporting.
Now there is no way to conceal anything because every information is with the
Income tax department.
everything. What I buy, immediately, they get the information. How much? Because select people, we cannot conceal a single money.
Single money.
Single money. Even capital gain and everything, I have seen. Whether I give it or not, it is already there in the
Everywhere. Even if you see this, sir, even case of trust, lot of international money is infused in for any political issues, militancy, everywhere, the trust. They are getting this trust, some donation from outside and using for different issues. The government is now very serious on the trust. Every 5 years you have to renew your trust registration. And the department is very serious how much every point you are paying or getting the money. Previously it has happened, some outside India they are used to send some money for trust. And trust is used it lot of time in Kashmir area and other areas. Lot of time they are using for the militant. Now it is fully checked. This a lot of money. I don't want to take the name. Because this one had happened in camera and before you, I can't say anything more because a lot of cases we get, we know, we see. But it's a very interesting. You are also telling that time, just what's the interesting cases? When you go through the cases, every case is interesting.
So
Yes,
is
sir.
there any specific mode? What are they?
That is first of all AIR information, annual information report. When you deposit the cash more than 50,000 as a saving bank, your details
So
will
cash
go.
transaction between me, let's say I'm buying a property, and
The
a part
property
transaction
detail-
I'm doing in
Correct.
cash.
Two things
So
are there. Suppose you are purchasing property in a 1 crore, okay? But this information gone directly to the department, okay? But if you pay this black money, that is not noted everywhere. That is never be reported. That is not possible. But that will come very minimum because you see, when you purchase a property, you paying 1 crore. Government always valued it more than that. 1 crore 20, 1 crore 30. So when it is more than 10%, this 20 lakhs rupees is come to your income, section 56. So if you pay the cash also 20 lakhs, what's your benefit? You never, sir. No, you will get it from your registration department that the valuation of the property is 1 crore 20 lakhs. But you and me very fairly we dealt in 1 crore. Clear? Particular to 20 lakhs. If it is within 10%, if it is within 10%, it will be, you will get the benefit. But the one thing is that there is problem is there. Suppose your property, it's this wide road, everything. Some property is back of the SME. There is no such in a winding road. Even there is no opening, all sides are blocked. So the value of this property cannot be calculated with this property. That may be 1 crore. That you can buy in 80 lakhs. That is the reason they are implemented one section in 55A, capital A, that you can claim for DVO, the Director of Valuation Officer. The DVO is another department of the income tax that is under the CPWD department. The person will come, the officer will come, they will verify your genuinity because rate is depending on the position. Suppose it's use the marble, you have not used the marble. Sometimes your openings are not very wide opening, they are very wide opening. So a lot of things are there, accordingly the price sustained. So the person will come, they will verify, and this issue you can make an appeal also. This is not correct. It is a genuine 1 crore transaction and that is my value, and that will be properly accepted by the court of law. That is properly accepted, and that is the beauty of our India, is our constitution. Every time they are giving you a right to explain, they give you the right to say something, and that is the only Bhagavad Gita, Quran, whatever you tell, that is our constitution of India. That is the beauty. And I feel so we are really blessed that we are in India. If you see the other countries also, we are really blessed of our constitution of India. Give you the each and every right. Whatever you have a grievance, you have a right to say something. Only the issue you don't know. But as a lawyer, your duty not only earn the money, you have a duty to educate the other person, to give some service to other person. You know. That is very important. Sometimes we see the miscarriage of justice happen because we are, after all are the human being. Sometimes happened, it has happened. But lawyer has a duty. Very seriously you go through the cases, very seriously you act on, and as a lawyer it's like that of doctor. You are the social doctor. Anything? Thank you. Thank you.
Thank you so much, sir, for such a wonderful, thought-provoking and enlightening session. Your insights into these various aspects of Income Tax Act have indeed broadened our understanding and given us much to reflect upon. Thank you so much. Now, every meaningful event deserves a graceful closure. To deliver the vote of thanks and to formally express our gratitude, I'd now like to invite Professor Pooja Singh to kindly come forward and present the vote of thanks.
Good afternoon, everyone. On behalf of Sister Nivedita University and the School of Law, I take this opportunity to extend a heartfelt gratitude to Mr. Anikesh Banerjee, sir, Judicial Member of the Income Tax Appellate Tribunal, Mumbai, for gracing us with his presence today and delivering such an insightful session on assessment, search, procedures, penalties, and appeal under the Income Tax Act of 1961. Your discourse has not only deepened our understanding of assessment procedures, search mechanisms, and penalty provisions, but also enriched us with the practical perspectives drawn from judicial experiences. I'm sure our students have greatly benefited from the clarity, depth, and relevance of your deliberation. Thank you so much. I would also like to thank our Honorable Vice Chancellor, Sir, Pro Vice Chancellor, Sir, Registrar, Sir, Dr. Debashri Mukherjee, Ma'am, Dean, School of Law, Dr. Manik Chakrabarti, Sir, Professor Emeritus, School of Law, Dr. Banhita Bose, Ma'am, HOD, School of Law, and all the faculty members for their encouragement and support in organizing the seminar. A special thanks goes to the organizing team and also the mentors for their efforts in preparing the students for this interactive session. Most importantly, I thank our students for their attentive participation and thoughtful engagement. Your active involvement has made today's seminar more meaningful. Once again, we express our sincere gratitude to you, sir, for sharing your time and wisdom with us. We'll look forward for so many more such enriching interactions in the future. Thank you all.
So, with this, we come to the conclusion of today's seminar. Thank you all of you for your presence and your participation. Wishing you for a wonderful day ahead. Thank you so much. Thank you, sir. Thank you, ma'am. Thank you. Hello.